Hey guys, come on in. Hello, hello, hello. Type in freedom now. Today is Monday, March 30th. Thank you so much for joining me. Today we have some break-in immigration news to discuss, in addition to the Q&A segment, which is my favorite part of the show. So come on in, friends, and let me know how you're feeling and where you're joining from. Thank you so much for the gifts on TikTok. Hello there, Instagram. Thank you so much for being here. Good afternoon. As you're coming on board, of course, as usual, type in freedom now. If the audio is crystal clear on your end, type in clear, 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 clear. Audio is clear. It's so good to be with you guys. I hope you had a terrific weekend. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in immigration freedom, we believe in experience, and we certainly believe in peace. We could all use a little bit more of on the peace side of things. It's great to have you guys with me today. We could be reached at McBean Law at 914-898-9488. And certainly wherever you're watching today, you'll find our contact information in the bio page, okay? Someone said to me during a consultation a few weeks ago, he said, it took me forever to find your phone number. I could not find your phone number. And but I do watch your videos, but I just can't find your phone number. And I thought, and then I asked him, well, where are you watching? And he said TikTok. And I thought, wow, well, the phone number is on TikTok on the bio page, but sometimes folks don't always know that. So just for your reference, it's on the bio page, okay? 914-898-9488. If you're ready to begin your journey with us at McBean Law, we're here for you. It starts with a paid consultation with an attorney at our firm. We meet with folks in person here in White Plains, New York, and also by Zoom across the country and the world, and also by telephone. So reach out to us to get started one-on-one with your immigration case. Now, let's talk about this breaking news, guys. Breaking news. And it has to do with the fact that USCIS, or the Department of Homeland Security, it is being reported that by CBS News that the Department of Homeland Security has made the decision to lift the pause, the adjudication pause that it has on asylum applications only. Okay, asylum applications involving individuals who are not from one of those 39 travel ban countries. So the 39 countries are still facing the adjudication pause that we filed our lawsuit last week. We filed on March 20th, we filed a lawsuit. And then last week, we filed our preliminary injunction with regard to the 39 country adjudication hold at USCIS. So that's still on. They are still pausing all of those applications: asylum, work permit, the green card, the naturalization process. All of those steps and processes are still paused. What they have decided to do, according to sources that reported out to CBS News, what they've decided to do is to lift the asylum pause on non-high risk and non-high risk countries. And high risk countries are considered those travel ban countries, the partially restricted as well as the fully restricted countries. So Trump administration is scaling back on asylum crackdown enacted after DC National Guard shooting. It says here in the article that the administration has decided to lift the asylum adjudication pause for most cases, except for those filed by nationals from countries affected by a travel ban. Um, the asylum freeze will remain in place for immigrants from 39 nations whose citizens currently face full or partial entry restrictions under the travel ban proclamation, which Mr. Trump expanded in December. And that list includes African countries like Senegal, Somalia, and Nigeria, Asian countries like Afghanistan, Iran, and Laos, and Caribbean and Latin American countries such as Cuba, Haiti, and Venezuela. The full list is on our website, and I'll place that list here again. All of these countries here in front of you guys here on McBean Immigration TV and Facebook. These are the 39 countries that are still facing the USCIS adjudication pause. If your country is not listed here and you have an asylum case pending at USCIS, DHS through CBS News is reporting that they are going to lift that asylum pause on your application. In a statement to CBS News on Sunday, the Department of Homeland Security confirmed USCIS has lifted the adjudicative hold for thoroughly screened asylum seekers from non-high-risk countries. Okay, but everything else, but for the 39 countries, that ban is still in effect. The pause is still in effect, and we're in the middle of our lawsuit. Well, it just started. It's early, and if you're one of our 99 plaintiffs, you get periodic emails from me, and you are connected to our litigation tracking webpage, so that you could see some updates about the case. So stay tuned for further updates about our case. We already have a judge, and I've already shared some information with you guys most recently. So that is the first news, okay? Now, if you're from one of those non-high-risk countries who USCIS has just lifted the pause on, prepare yourself, okay? Prepare yourself for your interview. Prepare yourself for the scrutiny that's going to come with your case. They are very serious now in terms of how they're reviewing, much more serious, I should say, with regard to how they're reviewing those asylum cases. So you really have to know what you're doing. And for some of you, you know that you don't have a good asylum case, okay? For others, your case is good. Circumstances might have changed. Speak with an attorney about what those changed circumstances mean for your pending asylum case at USCIS. All right. So this is great news for those of you who are not from one of those 39 travel ban countries. Someone says this is great news. Your asylum case it's gonna move. Okay, they're moving on those. So that is good news. I do agree with that statement. Next, guys, not so great news. Not so great news, all right, has to do with the fact that a second circuit, another circuit court system, I should say, has made the decision that individuals who enter the United States without inspection, who are later arrested by ICE, they're not entitled to a bond to be released, not entitled to a bond. Last week, the Eighth Circuit Court of Appeals ruled that there's no bond for those who entered in that manner. It doesn't matter how long you've been in the United States. You could have been here for 10 years. So long as you entered without inspection and you're in ICE's custody, you're not entitled to a bond. This is the second circuit that has made this decision. The first was the Fifth Circuit with the same ruling. The Fifth Circuit covers Louisiana, Mississippi, and Texas. The Eighth Circuit covers Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. Now, this is a case that it came out of Minnesota, guys. It came out of Minnesota involving an individual who's from Mexico. He was arrested in Minneapolis last August, and he didn't have any paperwork on him. He doesn't have lawful status, and DHS detained him without the possibility of being granted a bond. And they started the removal process against him. A federal district court granted his habeas petition requests for his release, and the government appealed that decision. And this is the appeals decision that we have in front of us. It was issued last week. The Eighth Circuit reversed that decision by the lower court and said no bond for individuals who are in the United States who are later arrested by ICE. Now, you might be saying, well, I don't live in the Fifth Circuit, and I certainly don't live in the Eighth Circuit. I'm right here in New York. I'm in New York with where you are, McBean, and so that means I'm safe. And you know what you should consider is this: that although an individual might be residing outside of one of these states, and they're arrested, they can be transferred by ICE quickly to either the Fifth Circuit or the Eighth Circuit, where they know that they have a much more favorable environment through the court system. So if you're detained, you guys have to immediately work with an immigration attorney to see what can be done for you to maybe stop your transfer, prevent you from being transferred outside of your district. Things with immigration, as you guys can see, you know, or maybe not, you might see this, I don't know. Um, it's it's not as intense, right, as it was, I don't know, a few months ago, right? Back in the fall, it was really crazy, and last summer. Things are still bad, of course, but not to the extent that we're seeing, and that's because of political reasons. The government has decided to scale back on what the public sees with regard to ICE crackdown, and so you're not seeing as much activities happening, but certainly they're still detaining people. They're still placing individuals in removal, and they're doing a lot of that, actually, placing a lot of people in removal proceedings, and they're still trying to get folks out of the country. So you have to immediately lawyer up if you're in that type of situation of being detained by ICE. Now let's shift to some good news before I get into your Q&As. And the good news has to do with the visa bulletin. The visa bulletin is for April. It's out, as I've mentioned to you before, and it's actually good. What's happening now, guys, is more visas are becoming available because of the immigrant visa pause against 75 countries. Okay, and then the USCIS adjudication hold. So it's freeing up more visas to be made available to individuals in different categories. So we know F2A, that category is current for, and I've spoken with you before about who could qualify to do adjustment of status under this F2A category: spouses and children, unmarried children under the age of 21 of green card holders who meet certain criteria. Go back and watch my video about that. Don't just jump into it. Really know the process, right, before you do it. That category is current, and let's see if I could get you over into, yeah, here we go. Then you have on the employment side, the EB2 and EB3 category, and I'm looking at dates for filing for employment-based visa applications. EB2 and EB3, guys, for most countries are, those categories are current as well, except for China and India. And so, for instance, if you are you're an exceptional individual, professionally speaking, and you'd like to, you know, start the national interest waiver process, the NIW process under EB2, in which you will bypass the labor certification process, you might very well be qualified to proceed with adjustment of status under the EB2 national interest waiver process. Definitely reach out to us. You must obviously be in lawful status in order for this to work. So take a look at the April visa bulletin, guys. There's some great opportunities there for certain categories to move forward with adjustment of status. We'd be happy to help you sort this out, but you know, come to us if you're in lawful status still here in the United States. If you're not in lawful status, this won't work for you with respect to adjustment of status. All right, guys, so let's get into your questions today. Let's go into some immigration questions today. Let's see. Let's go up here. Thank you, guys. I see Zimbabwe is in the house. Indiana is in the house. Florida. Awesome. Again, friends, we're reachable at McBean Law. Meet with us one-on-one for a consultation. Let's see. I'm a green card holder and my son crossed the border. Can I file for him? Green card holders can file for their children, their young children and adult children through an I-130 process. The way that your son entered the United States, however, disqualifies him from the adjustment of status process through you, unless one day or somehow he's qualified for a parole in place process. If he has a certain member of his family who is in the military, that could allow him to adjust his status. But you could you're limited at this point to just an I-130 case for him. Maine is in the house. Okay. Is the pause lifted for the 75 countries? No, the pause is not lifted for the 75 countries. It is still there. It's still indefinite. And we're working on our lawsuit, also gearing up to file that one next. Thank you, guys. My dad has been given a 221G paper. So for this person on Instagram, it's that your father has been placed in administrative processing at the U.S. Embassy wherever he was interviewed. So you could reach out to us so that we could see what the reason was. We'll see whether it was based on this awful 75 country pause or something else. Let's go, guys. Great questions today. Great questions today. Thank you so much for being here. Thank you for your gifts on TikTok. Double tap that screen as well on TikTok. Thank you. My immigration lawyer has said that it will take 4 years to pardon my spouse for the petition to work. Does it normally take that long? So Roberto, it takes on average about 3 years. Okay. On if it's the 601A waiver that we're discussing here, I don't know if it's a different type of waiver, but yes, the 601A process can take 3 years or even 4 years. It just really depends on your case. Can the immigration judge administratively dismiss the case at the master calendar? It's possible for a judge to, for your lawyer to seek dismissal even before you reach a stage, I should say, in the proceeding. But in most cases, it doesn't happen that way, and certainly not at that master calendar hearing for most cases. But we've in the past filed our motion for dismissal for some cases and the judge granted that motion before the client and us even appeared in court and followed through with certain steps. But it just really depends on your facts. Most times you obviously need to go through that master calendar hearing process. Those procedures are are the first steps. The first step in the process. Thank you, guys. Let's see, double tap the screen. How long will the pause take? No one knows. No one knows how long. That's why it's called indefinite. Indefinite. I know that it is different for every case, but roughly, how much would you recommend someone saves to start the naturalization application process? So it depends on, like you said, the case. If this is a straightforward case, and it also depends on your location. For some people, they would need to save maybe, I don't know, depends on the location. For some people, it could be something like 2,500 through 3,000 dollars. For other people, it could go very far up north beyond that. It just really depends on their case, their background, and the attorney's experience and location and some other factors. If the individual nowadays, naturalization is a lot more complex because of the good moral character review. It's more intense now. And so, yeah, I would say it depends on all of those facts, but starting to save, that's a good idea. That is definitely a good idea. Let's go. Freedom now, guys. And thank you for those of you who took advantage of our March Naturalization Month, where for us at McBean Law, we had our 50% off attorney fees for straightforward naturalization cases. All right, let's go. Okay, let's go up here. Freedom now. And also, if you'd like to find out if your country is on a travel ban list, you could simply Google the question. The AI that's built into Google is amazing, and it will answer your question. So, for instance, is the DRC on a travel ban list? And if so, which one? And you'll get your response. Okay, let's go. Let's go. EB3 category on the visa bulletin is current. Check out the visa bulletin. Check it out for April, guys. Check it out. What are the requirements to petition? What are the requirements to petition for the father? Is it to petition for your father? Is it a hard case to file? If that's what you're asking there, normally it is not a very challenging process to petition for an adult son or daughter can file for their parent. It is really normally a very straightforward process. You could take a look at the I-130 instructions on how to do that. The case can be filed online, or you can mail it in. It's a very straightforward process. Hey there, come on in. Good to see you guys. Hey there, Maxine. Thank you so much, Ketley. Thank you for being here. If you're now joining, earlier I shared the fact that it is being reported by CBS News that DHS has lifted the adjudication pause on asylum applications for individuals who are not from one of those 39 travel ban countries. That's what's been lifted. But those of you who are from a travel ban country, your applications at USCIS are still tied up at this time. My question is USCIS still approving green card for asylum applicants after the pause? Because last week USCIS reached out to me saying there has been a process and action taken on my case. USCIS is now, if you're not from one of those 39 travel ban countries, USCIS is moving forward with your application. I see a question here on Instagram about a criminal record from 25 years ago. You could meet one-on-one with us about that if you so choose to, or speak with another attorney. Normally, certainly a DUI is not, DUIs generally by immigration were not treated very seriously. But, this policy environment, it's different. Things are harder now with any degree of criminal record. So you could meet with us so that we could just pull the whole background together and advise you how we would approach the case, and also to even find out what type of case you possibly would be putting forward to USCIS. Let's see, I'll go ahead and keep on the screen here the 39 countries. Someone is asking me on Instagram if you're an applicant from Venezuela and you have an I-130, is that case still paused? Venezuela is one of those 39 travel ban countries, and USCIS is not proceeding with those applications at this time. And even some U.S. citizens who are from one of these travel ban countries, they're impacted by this adjudication pause as well. And we've had people meet with us in that very circumstance. And some of our plaintiffs in our lawsuit are U.S. citizens as well, who are from one of those 39 countries. And USCIS has said, we're not moving forward with your case. Sorry, but you're from a high risk country. And so therefore your case has been paused. Double tap the screen, guys. Let me know how you're feeling today and where you're joining from, and certainly type in Freedom Now. We're having our Q&A segment of our Freedom Now show. Let's see. Let's go back up here. Let's go to, someone is asking a question. I'm going to see if I could keep that up on the screen. Someone is asking the question about Pakistan. Has the pause been lifted off Pakistan? To my knowledge, Pakistan is on the 75 country immigrant visa pause list. And so that's still on. Just so you know, guys, there's so much going on with immigration. There are different pauses all over the, all, that I discuss. And you have to just divide it this way. Is yours a case that is pending at USCIS, or is your case pending at the immigrant visa embassy or consulate level? Okay, because there are two different pauses right now that's in effect. If it's at the USCIS, then your case is paused if you're a national from one of those 39 countries. If you're trying to get your visa through the US Embassy and immigrant visa process, you have to consider whether your country is on the 75 country pause list. Two different pauses, two different types of implications. We're tackling both of those through litigation for our plaintiffs. How can the government keep people in detention or jail without the possibility of a bond, potentially wait in years for a hearing? Well, the government it's not their intention to keep folks there for years. It is really their intention to make the conditions so bad that you would be forced or compelled to leave, to sign yourself out, so to speak, right, through pressure, and to voluntarily leave the United States, sign some papers and leave. And now with policies like these ones, and the courts are enforcing them, it adds a lot more pressure on individuals to depart the United States, which is the ultimate goal. And so the habeas process was put in place, obviously, to challenge the unlawful and indefinite detention of individuals by allowing a federal judge, to take a look at your detention and determine whether you're a danger to society or a flight risk, and make a decision to release you based on those criteria. And so now there's this conflict. There's this conflict with these circuit courts saying, based on the INA, based on immigration laws, federal laws, certain individuals do not qualify for a bond based on how they came to the United States and how they're classified in our law, under our law. And it's very crystal clear in the law what it says about that. That's the government's argument. And so I think eventually, obviously, this is going to go up to the Supreme Court because of there's conflict here. There's conflict with regard to how this issue is being treated. There's a split among these various courts. Type in Freedom Now, guys. And I'm looking for something easier to talk about next. Something a little easier. I know that you guys are super sophisticated and smart about immigration by now. Is the pause also on for T visa applicant cases involving those children who are living in Jamaica, a child living in Jamaica? So Jamaica is subject to the 75 country adjudication pause. If you're from Jamaica, guys, and your case is pending at the US Embassy for a green card for the green card process, our lawsuit, the way that it works is they're going to bring you right in front of that officer. You're going to have an interview, and then they're going to refuse it, which is why it's so important to consider pushing back through lawsuits, or you could wait. You could wait to see what happens. You have the option always to just wait. It's your decision. Depends on how urgent things are for you. Please explain what happens at an I-130 interview. Someone is asking on TikTok. So at an I-130 interview, the petitioner, whoever filed for you, usually the spouse, um, let's just use the spouse context here. So you bring your petitioners there with you, and the government will ask you whether you'd like to make any updates or changes to your application, and then ask you some background questions, each of you some background questions. In the spousal case or context, sometimes they separate people and ask you to wait outside while, they interview your spouse only and ask various questions of your spouse, and then bring you in and ask you questions. That could also happen at the first interview as well. Once they go through some background questions, if there's nothing there to really explore, and no major issues like previous violence, previous denials, immigration problems on your record, or criminal issues, it'll be over. It won't be a very long interview. If you're missing some documents, they will tell you that they need some more. They need more, and they'll issue you a request for evidence, give you a letter telling you, please, deliver these documents to us so that we could finish the process. And then they let you go, and you hear from them very quickly. Normally, if they're going to approve the case, it happens very swiftly, and that's that. Okay. Now, for those of you who work with us, you're working with us because usually it's not like that. Usually you have a lot more going on than that. And for those of you who have more going on, have a one-on-one discussion with us about those issues. Are marriage petitions also on pause for couples from one of the banned countries who are, I didn't catch the last part. Is it outside of the United States? So if you're, the application process at USCIS, let's say you have an I-130 case that's pending at USCIS, and US citizen, you're a US citizen, and you're filing for your wife, and your wife is, let's say, from Cameroon. Cameroon is not one of those 39 travel ban countries. Okay. But Cameroon, however, is on the visa pause. It's a visa pause country. USCIS will proceed with the I-130 case for that US citizen petitioner, unless that US citizen petitioner is from Antigua, right? Antigua is on the USCIS 39 country list. So although the wife in Cameroon is not on that 39 country list, the US citizen is, and then there goes that I-130 process. Now, let's say that US citizen is not from Antigua. Let's say he is from Jamaica. Let's say he's from Jamaica, and he's petitioning for his wife in Cameroon. Well, his I-130 will be processed and be approved. If it's a good case, then it will go over to the visa center, and then the wife now, Cameroon is on the 75 country list. So now the immigrant visa for her won't be issued because of that. What an awful situation, right? Because if there are different ways that they could hit you with something like this. And the people who are not impacted by this are US citizens who are not part of one of those the 39 countries. If you're not part of that U.S. citizen from one of those countries, you're in the clear. And then your spouse or children, whoever you're petitioning for, they cannot be part of one of those 75. Then those people are clear too to come in. So they're trying to narrow the pool, limit the pool of people who would be eligible for an immigrant visa, which is why space is available now in the visa bulletin, freeing up more visas for folks to pursue. I feel like I've earned my paycheck today and it's time to go home. It's a half a day of work. Let's end the workday at 1:45 p.m. Let's do it in a dignified way. That was too much heavy lifting. It's just mind blowing when you think about it, guys, what they're doing. It's awful, but we're here pushing back. We're pushing back. Let's go, guys. DACA renewals are taking forever. Someone is saying here they are. I don't know how that judge can sleep at night. They're just really dragging their feet with DACA. It's for today's March 30th. Let's see. Is it possible for me to change my status to remain in the United States for health-related reasons through workers' compensation? I'm a J1 teacher. My visa is expiring next month. Now, change your status to what, though? Just because you might have a work-related claim doesn't necessarily mean you have the right or the ability to stay in the United States. Immigration doesn't really care, right? That's just to put it that way. They don't really connect the real dots of how things like this, when they happen, how it could impact an individual. If you have a reason, however, to extend your stay somehow, um, you know, it might be possible to go from one visa type to the next visa type on the non-immigrant visa side of things. But the other question to consider is, what are the restrictions on your J1 visa? Does your J1 visa require you to spend, 2 years back in your home country? At the end of your cycle there, that's what could really impact things. Since my wife's country is on the 75 visa pause, should I wait to do my I-130 case? No, I don't think you should wait on your I-130. I think you should go ahead and pursue it because the you want to get her case in line for processing at the USCIS level. Freedom Now, guys, thank you so much for being with me today. I'm going to take a few more questions before we wrap up for the day. Thank you. Let's see. Type in your question. It's going so fast on TikTok there. Fiance visa, someone's asking about that. That process still works for these countries that are on pause. If you're from one of those 75 country pause lists, you can consider the fiance visa if you're not already married. I haven't received any updates about my hearing since the pandemic. Is there anything I can do to expedite the hearing? So this individual sounds to be in immigration court proceedings, and it sounds like you're waiting on what your individual hearing, your final hearing. Contact us first to take a look at what's happening there. It's hard, of course, to change. It's really, really hard, actually, to change the docket. What we would be looking for certainly is there a way that we could get you out of this, right? Is there a way for a dismissal? Is there any opportunity at USCIS that you have waiting for you, but the immigration court process is interfering with that? Or is it a case where your only relief is asylum, and it didn't work out with USCIS, and so now you're just waiting for your next hearing to come up in court. If it's an asylum case and we don't think it's an amazing case, we wouldn't really push it and advance things in court. Thank you so much for being here. Let's see. My father is a green card holder. Can he petition for my married sister to be his caregiver? And how long is it going to take for her to come here? So you're talking about the father petitioning for his married daughter as an employer, so that she could come to the United States to be his caregiver. I think that's going to be hard to achieve. It really, it really depends. This process will involve a labor certification, and by the Department of Labor, they'll have to approve that process and wages. And why is no other person here in the United States able to take this low-paying job? That's going to be part of the consideration. But if you're successful with getting that perm approved, labor certification approved, then, certainly you could chart ahead at USCIS. I think it's going to be a challenging one to achieve. Freedom Now. Starting in April, you mentioned that if a person is a green card holder filing for her spouse or husband, the beneficiary can do adjustment of status. It means things are proceeding. So in order for this to be successful, that green card, the spouse, the beneficiary would need to prove that they're in lawful status. They're in lawful status here in the United States for adjustment of status, and they've always been in lawful status. If they're here on a visa and they're still within that I-94 period, the I-94 has not expired. I'm not talking about the visa expiration. I'm talking about the I-94, the record of your entry and exit. That's what's key here. If they're still within that 6 months, if the government gave you 6 months, gave that person 6 months, and they're still within that 6 months, they have not stayed outside of that 6 months, they've never worked in the United States without authorization, they could proceed with adjustment of status according to the April Visa Bulletin. Those are the criteria that really need to be met there. Thank you. Double tap the screen on TikTok. Let's go. No news on DACA. I do not have any news right now. It's kind of hard. Okay. Let's see. Hard to see those questions. They're coming in very quickly there. I've paid the filing fee for my N-400 form, and I've also passed the interview, but I'm from one of those 39 countries. So I paid and passed an interview for nothing. Well, that's why we're pushing back, because they're supposed to do their part of the bargain, right? They said to pay the fee, and they are statutorily required to follow through and take your case on a case-by-case basis and make a decision on it. And if you're eligible for naturalization, then give you that naturalization certificate. That's as simple as it is. They do not have the ability legally to do what they're doing. Um, you didn't do it for nothing. Hopefully, you've joined our lawsuit. I'm not sure if you're one of our plaintiffs. Can an American citizen who is working for the government relocate his family to America from Sierra Leone? Unfortunately, so you're a U.S. citizen. They won't really care who you're working for, who your employer is. The question is your country on any of the ban lists? Is your country part of the 39 travel ban, which Sierra Leone is? Also, is your country on the 75 immigrant visa list? Those are the issues that will govern during this time. How much is your consultation fee? It's 300 for my colleagues and 399 for me. Thank you. Is it safe to apply for a work permit or should I wait until November? Well, what's going to happen in November? What First of all, what is it connected to? What is your work permit connected to? And what is going to happen in November? I'll need a little bit more facts there. Thank you. Okay, let's see. Um, My friend's case was rejected due to an attorney's error. She filed an employment based adjustment of status when the visa category was not current. He has no status. What are his options now? So the attorney filed adjustment of status prematurely. There's no visa that was available at that time. And uh, he has no status. Well, if the adjustment of status process wasn't going to work anyway, if this individual doesn't have lawful status in the United States. So that wasn't continuously maintained a lawful status, I should say. So the process wasn't going to work from the beginning, it sounds like to me. Thank you. Let's see. I see that my colleague in the chat is sharing information about our free guides. They're sending some free guides to folks on Facebook, it looks like. Um, if you guys go to mcbeanlaw.com/free, you'll see that we have resources there available for download. It's free. Our resources on our website, mcbeanlaw.com/free. Do parents go to the interview if the child is filing for them? Normally, there is no interview. Sometimes they do call a parent in, however, for an interview in rare cases, limited cases, when maybe the parent has some information on their record that the government wants some more answers about. So sometimes they will call the parent in for the interview. Thank you. The pause has not been lifted for any particular country. Someone is asking, has the pause been lifted for Ethiopia? I'm assuming you're referring to the 75 country pause. No. It would be nice for them to begin doing that, right? To say, okay, you don't need to be on that pause list anymore. You don't need to be on it anymore. Why don't we just lift the whole thing? Because it's stupid, right? Why are we doing this? How can we try to defend this? Um, okay, let's go. Is there a ban on adjustment of status for Nigerians who are living in the United States? Yes, Nigeria is on the 39 country Oh, hold on one second. Is it? Let me see. Yes, it is. We have a lot of plaintiffs too from Nigeria in our lawsuit. Nigeria is on the list. So, unfortunately, the adjustment of status process is impacted. I blanked. Thank you for asking that. Yes, the pause is still in effect for Nigerians. Okay. Let's go down a little bit. Freedom Now. My friend has just been charged for domestic violence. He's eligible to file for citizenship through marriage, the 3-year early citizenship process. The situation is a lie. Will this affect him in the future? So the allegations that are part of that domestic violence case, the allegations aren't true, and he is now eligible for naturalization at the 3-year early naturalization mark. I would want to take a look at the incident. I would want to know what is on the record related to that incident, and what also is going on with the marriage. Are they still together in a good way, and was involved in this domestic violence charge? Was it a spousal dispute, or was a child involved, or who who are the parties here, right? And dive a little deeper before recommending naturalization. So that person can reach out to us for a private one-on-one discussion. Okay. I think I answered this earlier. What if the spouse is not from a banned country and the partner is from a banned country? How will they manage this? So it depends on who the petition. So uh, earlier I described various scenarios involving the U.S. citizen petitioner being from the banned country versus not being from the banned country, and then the beneficiary spouse being from a banned country. You could go back and once this session is over, and listen to that segment, that response. It just depends on, the circumstances involving the petitioner being from a banned country or not, and how far the case is. Where is the case? Um, where is the case? Is it at the U.S. Embassy level or here in the United States? Can a green card holder file for a spouse who is lawful in the United States and do adjustment of status? According to the visa bulletin for April, yes, they can do adjustment of status, provided that that spouse has never worked in the United States without authorization. Thank you for being here with me today. Let's see. Thank you. Um, Can my brother safely apply for citizenship if he obtained his green card after his case was decided by the BIA? It might be possible. It might it so so this person, I don't know if his case in the past was denied and there was an appeal or a reopening process, or whether he was in removal and got a removal order and his case went on appeal to the BIA. I don't know what those facts are. So during a one-on-one consultation, I would dive deeper into the background, and if there are anything that is on his record that makes me pause, I will pause and say why. Okay. Um, Yeah, and I would consider too where he would be interviewing for the naturalization because that could certainly play a role. I have such a big testimony to share with you guys by video, which I'm going to do by video. We shared it yesterday to our email list, and it's on our website currently. So go to mcbeanlaw.com/success and read an amazing story involving one of our clients who was unlawfully detained at his green card interview after we had gotten him a joint motion to reopen and terminate his removal case approved. And then we had to go get him a bond and defend him in court. Again, he was dragged back into the immigration removal process a second time unjustly. And we won his green card in court with a waiver because there's misrepresentation and fraud on his record. So the judge approved the waiver as well in court. And the government never appealed. The government didn't even reserve its rights to appeal. The government knew they were wrong to drag this man back into the system in such a terrible, discriminatory way. And we're so pleased with the outcome. But there's more to it than this. And I'll share more details over time. I will get that out to you guys because I think it will really encourage a lot of people. So just know that the immigration journey can sometimes be really, sometimes it can seem like it's out of your control, but you have to get good help. You have to get some experienced help. You have to stay with it. You have to keep the faith. And it's a journey. If you're ready to begin this journey with us, you could take the first step by reaching out to us at 914-898-9488 for a consultation. And if it works out where we think that you have, there's a way forward, we'll go on this journey with you. Okay. Thank you so much, friends, for being with me. Thank you so much for being with me. And I'm looking forward to pressing on with you in the days ahead. Thanks so much, guys. And I will see you in the next one. Bye-bye.